132. That's how many people have been killed by drunk drivers on Wisconsin roadways for this year alone, putting us on pace for the deadliest year since 2015.
And this comes as the Wisconsin Supreme Court will vote to possibly ease the penalties for repeat offenders. The I-Team's Sean Gallagher talks to those who say this is a step in the wrong direction.
Marla Hall has been on TV too often since 2016.
Just can't believe it's only 5 years.
She still lights up when talking about her only child, her son Clinton. On this fall day at her Waterloo home, she remembered the time he met Brett Favre.
He was going to tell Brett, give him some tips on how to play the Cowboys.
But all she can share now are the memories in those photos. Clinton and 3 others were killed by a wrong-way drunk driver 5 years ago.
I'd be a grandma. He told me when he was 30 I could be grandma. He lost his future. There's no future, no marriage, no kids. You're never the same. It's hard to be happy. Everything changes.
After Clinton was killed, Marla became a champion for stricter drunk driving laws in Wisconsin. TMJ4 was with her during her many trips to the state capitol, including last year when Governor Tony Evers signed 2 bills into law. One that creates a mandatory minimum sentence for drunk drivers who kill someone, and another that creates a mandatory minimum sentence for 5th and 6th time OWI offenders. But she admits the progress is slower than she wants.
I'm sick of saying baby steps. It's not fair.
Now she feels repeat offenders could get another pass. The Wisconsin State Supreme Court will rule on a case that started on this Jefferson County road some 25 years ago. Scott Fort was charged in 1996 for running from police and driving with a suspended license. He was also charged with his 5th OWI, and he refused to submit a blood sample during that, a charge that was later dismissed but read in. This means a judge can take the 5th OWI into account for sentencing, but the charge itself is dropped. It's the blood draw refusal at the root of today's Supreme Court case. That's because over the next 20 years, Fort racked up 2 more OWIs. His latest happened in 2017. He pleaded guilty, but his attorney argued it was for its 6th conviction, not his 7th. Fort's lawyers declined to comment on this story.
They couldn't count the refusal to provide a blood sample as a prior OWI.
Legal analyst Michael Mastelman says this is a big distinction. In Wisconsin, the more OWIs you have, the harsher the punishment. A 6th OWI is a Class G felony with 1 to 10 years in jail. A 7th OWI bumps it up to a Class F felony with 3 to 12.5 years in jail. A judge sentenced Fort to 6 years in prison under the impression this was his 7th OWI. Fort's lawyers filed an appeal claiming their client's constitutional rights were violated, and they won.
I think that our Wisconsin Supreme Court is going to uphold the decision of the Court of Appeals saying that you cannot use a refusal.
Mastelman says it's like the right to remain silent. If someone under arrest refuses to talk to police, a court can't hold that right against them. In Mastelman's eyes, refusing the blood test is essentially the same thing.
You have the right not to testify against yourself.
Should the Supreme Court rule in his favor, Fort's prison sentence could now be reduced by at least a year at a new sentencing hearing, and it could spark a wave of OWI offenders requesting new sentences. Consider Milwaukee County, where the district attorney says there are at least 150 blood draw refusals every year.
Do you view this as like a loophole that other people could exploit?
There could be quite a few people that have been charged and convicted of additional OWIs based upon the refusal, and they could try to collaterally attack that to reduce and to throw out one of the OWI convictions.
It's courtroom complexities like this that make Marla Hall feel helpless.
How many chances are we going to give these people? We're already giving them way too many chances, and it's destroying lives.
Right now, Marla's primary focus is on changing the first-time OWI offense in the state of Wisconsin. We are the only state in the country where a first-time drunk driver only gets a ticket. But she'll also keep eyes on how this case plays out. Both sides are expected to submit arguments later this month. Reporting for the I-Team, I'm Sean Gallagher.
Sean, thank you. This story part of our Project Drive Sober series, where we take a critical eye to Wisconsin's drunk driving laws. From cocktails to go to devices meant to keep drunk drivers off the road. See all of our investigations right now at tmj4.com/drivesober.